making sure I've been getting, and you've been making it. Yeah.
Hey, Terry. Good, how are you? Guess I should talk. Never mind. Judge Levis just needs a one.
Okay, we'll come back to order now. We're going to the next committee meeting, which is our Justice Committee meeting. There's one item there. Just a clarification, I believe we want to call that the Justice Committee. Yes. Our agenda erroneously says Criminal Justice, but I believe it's Justice Committee. I talked with Marie, and in the future we'll have it correctly labeled. Okay. April.
So I'm joined here with Councilmember Vargas and Borneman. Just to kind of give a little preface as to why we're here. For me, it become extremely clear over the past few years that Bellingham's community is very interested in the criminal justice system. Yet, due to its complexities, and it's really difficult to understand all the moving parts. So I really want to thank the Council for approving the Justice Committee. I also would like to thank Councilmember Vargas and Borneman for volunteering to be part of this committee. Councilmember Borneman has extensive work experience in the criminal justice system, and Councilmember Vargas has dedicated considerable time to understand the direct and indirect influences of the justice system. You both are valued committee members, and I look forward to working with you over the next few months. One order of housekeeping. I want to remind the committee members, the rest of council, staff, and constituents that in order to comply with the rules and regulations, this committee will not comment or enter into any discussion on the current jail use agreement or the ballot measure for public safety tax increase November 2017, just to make that very clear. The Justice Committee, in order to I think hopefully give our parameters a little bit, I kind of came up with 4 things here. And so, one, this is going to allow dedicated council time to explore and understand the complexities of the justice system. 2, allow constituents to learn alongside the council to develop a better understanding of the municipal justice system. 3, gives the council a direct and dedicated forum to the justice branch of the city to ensure continued communication and understanding of its work. 4, it leaves council poised to prepare for all outcomes of 2018. 1, further educating the council to be stewards of a potential new revenue source dedicated to providing alternatives to incarceration. And 2, further educate council preparing to explore sustainable alternatives. With that, we've invited Darlene Peterson and Judge Lev to give a 6-month report on the jail program impacts and a report on impacts of pretrial transfers to Yakima. Thank you for coming across the street. It's great to see you here.
In your court and our branch of government, Darlene is going to give you an overview of our alternatives. We're always looking for alternatives to jail. That's our mission, essentially, besides providing justice to everyone who comes before the court and access to the courts through our many programs, including our wonderful indigent representation, which is a model program for the state, and for which we have received grants for a number of years to sustain it. So I'm going to let Darlene give you that overview. If you have questions about court operations, we're happy to answer those even along the way.
Thank you. I'm going to start with Friendship Diversion Services, which is really, I believe, a star quality program that we have implemented as a city of Bellingham, in that everyone who participates on one of these bracelets is not in jail. And so that is really diverting people from being incarcerated. We started in March of 2016. Am I reverberating here?
Maybe that's right.
Okay. And I wanted to remind you that we have 2 kinds of bracelets. The first is a GPS bracelet, and that bracelet tells somebody's whereabouts at all times. The second kind of bracelet that we have is called a Scram Bracelet, and that bracelet merely detects if anyone is using alcohol. And we use those in different ways. For sentences, we use the GPS bracelet, because with that bracelet, it commits people to staying in their home, but allows them to go to school, to work, to treatment, to counseling, to probation parole appointments, scheduled court hearings, and attorney appointments. And all of these appointments are verified by Friendship Diversion Services. The Scram Bracelet is different in that it has a mechanism inside, and basically what it does is detect alcohol. And so what it's allowed us to do is we have a huge pocket. I think right now we had about 14 defendants who are on those Scram bracelets pre-trial. And the reason this is wonderful is because those defendants have consistent alcohol issues. They're not a one-time offender. They're somebody who has a chronic problem. And we're able to keep them out of the jail because when they have that bracelet on, any alcohol use is detected. If it's detected, they're immediately called in by probation, and probation does an alcohol test that goes back 3 to 5 days. It's called an ETG, and with that test, we can then verify have they indeed been using alcohol. And this is a big community concern with people with chronic alcohol issues, and so that's why that's been such a success for keeping pretrial people out of the jail. The other thing that with these bracelets the city does is supplement those who are indigent. So getting on the bracelet, there's no barrier if you don't have money. And that's been amazing. And you'll be amazing at the cost it's actually saved us to be supplementing these indigent folks. In 2016, we did 212 defendants on these bracelets. They served 390 days, or excuse me, 3,090 days in total. And we supplemented that with $14,757. The cost for 212 defendants to spend those 3,090 days in jail at last year's rate of $98 a day would have been $303,016. This year, we have already had 160 defendants in the first 6 months of this year serve on bracelets, and they have served 4,196 days. These are completed sentences. That cost the city $36,874 to supplement indigent defendants. Had those defendants served that time in jail, 4,196 days, at the current rate of $108 a day, that would have been $428,544. And not only the money, what we have to realize is that these defendants are maintaining their residences, they're staying employed, they're continuing their education, they're attending alcohol drug treatment, they appear for the court hearings and with their appointments with their attorneys. And the most amazing thing is when I went back through the defendants of both years, so that includes the 212 and the 160, which I believe is 372 if I'm doing math quickly enough. So those 372 defendants that have passed through that we've put on bracelets, only 7 of them are currently in warrant status. The other 360 something have completed their sentences. That is a 98% success rate. That is huge. And these are people 4,000 some days that we have not used the jail.
Darlene, I think Pinky has a quick
Yeah,
question.
Darlene, can I ask a quick question? When you say supplement, I know we talked about this before, but it's been a while.
Sure.
So a person who's going to be wearing a bracelet, they're paying for the cost of that? Is that correct? And then if they can't afford it, then the city is supplementing? Is that what we're talking about?
Yes.
And what's the cost again? Would you please remind me?
If there's one bracelet,
yeah,
it's $14.50 a day.
Okay.
If they have to end up wearing both, then it costs $25 a day.
Okay.
And we use the poverty scale for qualifying for a public defender. It's 125% of the poverty guideline. For the bracelets, we've upped that, so it's 150% of the poverty guideline. So anyone who's over that or under that, we're supplementing.
And Terry?
Does the current generation of bracelets require computer services at the home?
No.
Okay.
It does require
ones,
being able to have a cell phone,
Okay.
Okay.
and it has to download. If a person is not in an area where there's cell phone service, which these days is becoming pretty minimal. Then they come in until their phone can be downloaded, so they don't have to come all the way in, and then it's done on a daily basis. The second program we have is Yakima. Now that's not a diversion, because the people who are going to Yakima did not qualify for a bracelet. Everyone who's in jail, everyone who comes to court, they're all screened for a bracelet. So only those who don't qualify that are sent to Yakima. And the reason we're sending them there is because of what we've been asked to do by the Whatcom County Jail, which is the contract actually states that within 4 hours of their first hearing, we will send them over to Yakima. Because of jail constraints, we worked with Wendy Jones, and it's ended up being twice a week at this point. We sent 143 defendants over last year, and they served 3,200 plus days at a cost of about $55 a day. This year so far, we've sent 144 defendants within the first 6 months. It was already doubled within half a year, 3,300 days. And so because our costs here are $108 a day, you can see it's almost half of what we're paying here. And that may seem like a really good thing, and it is, anytime we can save money. But there are some issues that we're running into that are making those cost savings not as great as we would like to portray. And so at this point, I want to make sure that I leave time for Judge Lev to go a little bit more into what we're experiencing, and then we'll be happy to take any questions.
Also, I just want to add that there's no booking fees when they go over to Yakima. But
Judge Lev, do you mind? Mayor Kelly has a quick.
When
Yes.
the judge is finished,
Okay.
I have something to say.
Okay.
Okay.
Judge Lev.
So, and I want to make it very clear that our branch of government takes no stance whatsoever on the whole jail issue at all. We're neutral and detached, as we always are. Of course, we do need a jail facility. We all know that there are going to be some people that have to be housed and booked and housed. I wanted to add just a couple points to what Darlene had indicated. The GPS bracelet that she talked about as an alternative to jail. We do actually use that, and I used it this morning for someone who's not serving time, but we have to track. And we do track in DV cases as well, because we can give them a geographical.
Please say what DV stands for.
Domestic violence cases. We track some of those individuals that are released for safety concerns, and we give them restrictions as far as geographical locations that they're not permitted to enter when it's too close to the alleged victim or the victim. But I wanted to add that just this morning, I had to order GPS onto a defendant who has some pretty substantial mental health issues, and we're trying to accomplish a mental health evaluation by Western State. I wanted to keep him out of custody. We have tried for 10 months to keep him out of custody. He keeps there are situations, because I don't want to get too specific, but there are situations where individuals do not want to cooperate with mental health evaluations. And so we arranged, the attorneys arranged the eval, and then the person doesn't show up. And so that complicates things. And, we can't actually force a person physically, or we would like not to, have the eval, but it's necessary in order to have the process continue as far as the charges go. So after 2 times, the GPS can be used so we can locate the individual and assist him in getting over to the eval when it's all set up and the mental health professional is waiting for the client to arrive. So that's just another indication that we have GPS for those purposes. But I wanted to give you some understanding of when a person comes before you and they're charged with whatever criminal offense, the judicial officer has to take into account a lot of information in order to make that to determine the release conditions. And there's a lot of balancing going on. The individual's rights, of course, the community safety. There's just a lot of things that come into play. If we can get that person out of custody safely for the community and for that individual, because there are concerns sometimes with the individual's safety if they're out, then we'll use those tools that we have. And that's what Darlene's explained, that when we get to the point where we can have that person released from in custody, then they have to follow the court's orders on the conditions of release. A lot of times, again, this morning, we determined that it would be appropriate to have regular court reviews to kind of monitor what this person is doing while they're out, because the attorneys have to prepare the case, obviously, witnesses and all of that, but this person's out in our community, and we want to make sure that the individual defendant is safe and our community is as safe as we can with our conditions of release imposed. So we can have the person report back to court biweekly, once, whenever we want, actually, and have them sign a promise to appear to come back, and we just check in. Everyone checks in. Is it all going fine? If not, we make adjustments. So I just wanted you to understand that we get all this information at the initial appearance, and we have to make those determinations. If they do not follow the court's conditions of release, as Darlene's indicated, we get a notification. Probation gets the notification, the court gets the notification, the public defender or the private attorney gets the notification that there's an allegation this person's not following the orders on release conditions. And then that person reports to probation for the tests, like Darlene had indicated, the ETG test that will tell us whether that tamper was actual substance abuse, alcohol detected. There's all kinds of weird things that people can do with those bracelets. Just when I think I've heard it all, I hear something new, and it's just mind-boggling. But the addiction is strong, and any way that a person can try to avoid detection, some people will attempt. Once we have determined that it is a true detection, true tamper, the person is summoned to court. Actually, if they go into probation, they sign a promise to appear so we can get them in sooner. Quicker, because a summons takes time and you have to give notice and all that by the mandates of the law. So then we make either a determination of what additionally we need to do, whether the person has to be taken into custody, all kinds of things. Inpatient treatment, voluntary at that point if it's pretrial. Some of the issues, let me see if some of the issues that Darlene has indicated as far as the transfers go. Fortunately, we have some time to, not the 4-hour agreement, but the twice weekly, to make some decisions, because that takes a little bit of time to get information to make those decisions. NCIC reports give us the criminal history from across the United States. We don't have that always, most often not at the first appearance. So we need to know what kind of convictions they have out of state. We do have a lot of people traveling through our state or not here for very long. So I think one of the most significant problems that we're seeing is transferring mental health individuals that are not yet stabilized. And if you can imagine having any mental health issues and being transported across the mountains to Yakima when you're not stable to begin with, off meds or whatever the case may be, we certainly don't want to do anything of any cruel nature to anyone. But we're mandated to move these individuals out pretrial stage, and if we can't get them on a bracelet or some other way to stay locally, they're going to Yakima. Once they're in Yakima, it's a very good situation. They have a really good mental health process out there. They're seen quickly. They manage it really well, and they have the resources to do it. So once they're there, great. The transport is an issue, a pretty big issue, can be. We have our warrant officers that if these individuals refuse to get on the bus to transport, Yakima won't transport. If there's any indication they won't get on the bus, they don't want an issue, they won't transport. We still have to remove them from our local jail per the agreement. So our warrant officers, we have 2 warrant officers that come to our court proceedings. They have to be absent from our court proceedings and travel across the mountains and and this individual is transported over to Yakima. This doesn't always go smoothly. We have wonderful warrant officers. Oh my goodness, they couldn't be any better. They're humane, they're caring, they're just really wonderful human beings. And I think we told you the story about when one of the officers gave this individual his own shoes, the boots off of his own feet, because the individual came out of the Yakima hospital without anything, including shoes, and it was cold, wintertime. In any case, they have to transport them. We lose our officer safety coverage in the courtroom if they do have to transport. The other issue is Yakima Hospital will not treat substantial injuries of mental health, or anyone, I guess, any individual. So if this person receives some kind of an injury or has some medical situation going on, Yakima won't take them. They're transported over to Harborview from the eastern side. And there's a bunch of issues that arise that way. Harborview will not notify our court when they release, so we've had a situation where an individual was just released. It was a domestic violence case. We were tracking as best we could. We actually got a lot of information from family of the defendant in order to be able to get this person back in custody. And he had didn't he have pretty substantial mental health issues as well as the charges. So that's an issue where we don't get notification and the refusal to treat. These people are often combative. They're in a situation where they're not thinking clearly.
Judge Lev, may I ask a quick question?
Of course.
Just curious on the Harborview thing. Is their policy, is that a stat policy that they don't notify, or do we know what the challenge is there? Just kind of curious why they won't tell us.
Because the person is not in custody, there's not an officer there, and so just legally speaking, they're not bound. There's nothing that would indicate to them that they have to notify anyone.
Although I will say Yakima in this case told them that they needed to be notified immediately when this person was going to be released. But that what they found over and over again in time is that it doesn't happen. And so unless an officer is present with them at the hospital, many times this situation occurs. Even though they're notified to notify, they don't have a legal mandate to do it.
That's why it slips through the cracks. Okay. And also, there have been instances where the injuries are severe enough that the person has to be actually flown to Harborview. That's on the city's tab. And you're probably familiar with the costs of a helicopter ride or a fixed wing. Fixed wing's about $15,000. The helicopter's probably $30K per individual.
So one flight could take away all the savings of putting
potentially
hundreds
potentially
of people in Yakima with one emergency flight.
And part of the issue is we have a very cooperative arrangement with Peace Health, and a lot of that has come from work with the jail staff here. Part of that is that we have a very cooperative arrangement with Peace Health here, and part of that is all the work that the jail's done to establish that relationship. In Yakima, the hospital will only take their mildly needy defendants, and they have a contract where they have the right to refuse. And I think they've had a different situation over in Yakima. They don't have that same reciprocal work ability that we do with Whatcom County Jail.
And they also have an officer stand by while the person from Yakima is at the hospital receiving treatment, so they have an officer stand by there. And we have a different situation here through that kind of unwritten policy. I just wanted to also add in that the short fix versus the long term, it's very challenging for the court staff, I believe for the city attorney's staff, prosecutor's office, and for law enforcement. I'm not speaking for those agencies, but it is very challenging to administer all of this, the transports, the health concerns, the combativeness, the everything. And we're short-staffed to begin with, so we're finding it's very challenging for us to coordinate all of this and do the business at hand here locally. So I just wanted to just plant that seed again about the short-term versus the long-term fix here. Because if there is a jail to be built, in 5, 6 years, whatever, however long, we're sustaining for the moment. We're trying to sustain for the moment. I think without some kind of funding or administrative position to oversee this, it's going to take away from what we're trying to give here locally as well.
Chair Kelly, did you have a?
Just 3 quick things. First of all, the judge, so we only have one judge, the judge and court personnel, Darlene, especially who we have frequent contact with, we wouldn't be having the success if it wasn't for them.
Yes.
Because there's a different potential attitude or decisions being made across the street. So you guys, you deserve a lot of credit, and Ryan, and Peter, and I can't go on and on. Everybody who is working so hard to make sure that this is working out as best as it can in a bad situation. When I heard about the transport of the person with mental illness and the warrant officers, I met with the county executive, and I said it was my understanding that Sheriff Alpha had said that we would be working together to try to minimize the transport of pre-trial people or others who shouldn't be taken out of this jail and sent someplace else, even though they might get better treatment. And the county executive asked me to follow up with the sheriff. There's separate elected officials over there. So I'm making an appointment with the sheriff to talk to him about the transport issue and his, I believe, pledge that he would work with us on making this smoother. And secondly, I really suggested to the county executive, but I'm going to suggest maybe I suggested to Jack, but I'm going to maybe suggest to one of the council members that they have this presentation that Darlene has and the judge have just given on the effectiveness of friendship diversion, both on the treatment of the clients and the financial savings. Because I don't know if they have as clear a picture as we have about how that contract with Friendship has really worked out very, very well, both socially and economically for the city. And I know that our court system is not taking any chances with any kind of inmates or potential inmates that shouldn't be on a bracelet. So we are having good success that way. So that was another thing where it was suggested maybe I talk to the county council. So I will do that, and I don't know if that is, you're amenable to making a presentation or not, or sharing the information, because I think it speaks for itself.
I would have to agree. And I think if they had the information presented, maybe they would see that it really is a really effective tool. And I consider this a county.
Yeah.
So I think that we can all benefit if they can get more people out of custody on these bracelets and Scram, the alcohol detection bracelet. Then
But isn't part of the problem with the county, not with the judges necessarily, or with the county council, but with the prosecutor in terms of pretrial release and unwillingness to allow pretrial releases?
The judicial officer makes that decision with recommendations from either side and both sides. So perhaps if I haven't talked with the judges. I mean, I know the judges, obviously. I haven't talked with them about, one-on-one, just how I think this is a really effective tool. And I'd be
know
willing.
There's been a lot of pushback from the prosecutor
That's what I hear.
towards the bench.
That's what I hear. And I mean, all judges have that whole liability issue in the back of their heads, of course. But
so do you.
Of course I do. Every day, every moment of the day, I'm thinking, if I make this decision, what will happen or what could happen? And we can't control everything, obviously, but I think, I'm happy to talk with them about that.
I think that's a good suggestion, because that's what I've been hearing too, Terry, but I think that's only half the story.
So just want to, in the interest of time, we made this first one a little bit short so we could kind of feel out how this is going. I have two questions. One, Mayor, as you approach the sheriff, I think it was very encouraging, the email that we received that pretrials across the county were going to be created equally, and that was, I think, several months back. If you could get a report on how many county pretrials have been removed. I think in earnest, there's an agreement, and we need to be sure that all of our citizens, as part of the county and the city included in the county, are being treated equally that way. So I'd love to get a report at the next Justice Committee of how many county members pretrial are being removed. I wondered if you all had been brainstorming on, for those that are not able to be on any of the diversions that we have, but they're pretrial and we have to get them out 2 times a week, and you can clearly see that they're unstable. Is there any way that we as council can help you, whether it be directing funding, directing program, like what can we do to help that situation so maybe there's more time to get somebody stabilized before they're moved? Have you thought of anything that is out there, or is this just what it is?
We have that discussion a lot. It's just, it really does come down to funding. I mean, that usually is the problem with mental health issues. And I know we're in the works of the community court, but we somewhat stalled it a bit to see where Grace is and give a foundation, that we can maybe share resources and figure out programs that way.
Okay.
We'll also be working with the court as we develop the adjustments to the biennial budget.
Okay.
So that would be the best time to talk to Judge Lev and to Darlene and everyone who's involved in this back and forth and come up with some recommendations to present to you.
Okay. And in the interest of time, I'll ask if our committee members have any more. Pinky, before I open up to council.
Yeah, part of the reason that I really wanted to do this was to understand all the steps of our judicial process and who everyone is involved in making the decisions. And I think that I'd love to have it, like you said, okay, the decision is made by the judicial officer about whether they get moved or not. And I'll be frank with you, I don't know what a judicial officer is. So what I'm realizing is that there are all these things that, as we, I work for a utility. I know all those acronyms. But maybe we could, part of this committee could be starting to actually say this, you have to do this step, and then these NCI reports, and I'd love to know what all the steps are and things, and who people are and what they're responsible. I know that's a big request, but maybe through this process, that's something I would like to learn, is all the steps in our judicial process and who people are and what kind of decisions and how those decisions affect how our incarceration works. So that's something I want to get a better understanding.
How we directly and indirectly
can influence because you don't know all the things that have to happen, and obviously the implications of moving someone who might not be stable in a 4-hour period, and like all of those things. That's a lot of where my interest lies, is kind of really understanding it and then figuring out how we can support it.
Terry?
Yeah. Perhaps just a simple flow chart of how that works from somebody entering the system through might help with that process.
Yeah.
We can make it shorter than 3 years of law school, I assure you.
Excellent.
I'll open it to council, and then I'll come back to you if you don't mind. Dan?
Does the wellness court, which is the mental health court, or drug court compete with any programs or protocols within the standard court?
Like Fast Track? Or?
Well, so the example across the street is that Fast Track could compete with drug court. Do we have a similar type of issue?
Yeah.
Okay.
Mike? Oh, sorry.
We've got specialty courts, as you're aware, the domestic violence court, the mental health court, and we're hoping for a community court, maybe a DUI court down the road. Those are not competing interests. And maybe Commissioner Smiley can come talk with the Justice Committee sometime about mental health court, and when we're closer to a community court, maybe we can come and report on that. The specialty courts seem to work really well. I've done the DV specialty court for almost 15 years now, and it's working really well.
I think I know I had it in, we're not going to quite get to it, but I think learning more about maybe some of the barriers to entry with the mental health court and any way that we can directly or indirectly influence breaking those boundaries down and making that as readily used as possible would be a great maybe next step for this Justice Committee, Michael?
Yeah. With regard to the Superior Court across the street, there's been a lot of talk about bail practices. Just even learning what their bail practices are has been a difficult process. We now, as a result of the Veer Institute, understand more the county's bail practices, which they couldn't report to us because they were done on a case-by-case basis and no one was keeping track of what the effects were, what the outcome was. What are the bail practices in municipal court? Do we do bail? And if so, how does it operate at the municipal level?
We do, in those determinations of release, we do bail, imposition of bail or no imposition of bail. We do I would say quite a few personal recognizance release cases. Again, I think this goes to what you were requesting as far as understanding the process, and just step by step. But at the first appearance or arraignments, more likely, when there's advisement of the rights and the charge and all of that, then the court receives information back about, well, I have it before me on the computer, criminal history. I always ask how long they've been in this state, because if there's not a lot of criminal history here, there may be somewhere else. We don't have the NCIC generally at the first appearance, which gives us the nation history within the nation. So to answer your question as briefly as possible, yes, we consider bail in every case. A lot of them are PRs, released on personal recognizance, lawful behavior required. If it's a domestic violence or some case where there is a alleged victim or witness who needs protection, we have orders entered prohibiting contact. But the bail itself, the amount of bail, is that what you're curious about?
Well, the analysis for a Superior Court across the street, at least according to the Veer Institute numbers, is that it's not functioning as intended. And there's been some discussion for a while about how cash bail is counterproductive and how personal recognizance or monitored release has been underutilized. Now, I've been hearing a lot about that for Superior Court, and I have no idea whether we have similar or the same issues on this side of the street.
I don't think that we share the same issues that they may have there, because we have a lot of pretrial monitoring through our probation department. And you've heard me say it before. We have the most outstanding probation department in this state, in my opinion. And so I utilize probation for pretrial monitoring wherever it's appropriate. Domestic violence cases often have it. Alcohol and drug-related cases often have it. They're tested. They report. We can release these people without bail because we have them reporting and tested, and Scram, and all these other tools we're using. So we don't have those issues now because we have found these alternatives to bail.
Yeah, I think that's what I wanted to hear, because
now, there's another issue, there's another issue with the cash bail being a statewide concern, that courts may be using that as a tool to keep people in custody. That is not our position. I do order cash performance bails, or court-approved performance bonds, but those are only in cases where there is an indication to me that they will not follow their release conditions, and there is a danger to the community or the alleged victim.
Yeah, what I guess
Thank
I'm
you.
seeing is
Michael, I think in an interest of time, do you mind if we move on?
Okay.
Okay. So if that's something you could bring to me, and
I
we
want to
can
hear what
maybe
you
add
have
it
to
to the
say, the
Justice
leader.
Committee. So I did want to just read this quickly as we close up from the National Center for State Courts, that municipal courts can have a great influence over how the public perceives the justice system as a whole, since the principal and most common use case types of these courts include traffic and ordinance violations, small claims cases, domestic cases, misdemeanor offenses, and other preliminary proceedings and felony cases. And I think that's what's important about this Justice Committee, is you're having immediate influence over constituents, and clearly we're seeing that our culture is about trying to keep people out of jail, and I appreciate you coming to help us unpack and really learn about all of this. So thank you so much, Judge Lev and Darlene, for coming, and thank you to the Justice Committee. End of committee.
Thank you very much.
Thank you very much, Judge Lev. We'll take